So if it's anything under $300, it's a misdemeanor.
But I don't know how much it was.
We'll figure it out.
Stupid stuffed animal was like, this is, like, I don't know why.
So if it's anything under $300,
On November 21st, 2025, body cam footage captured a retail theft investigation that presents critical questions about Miranda procedures, right to counsel invocations, and first-time offender processing.
I promise you.
Hello.
Yeah.
So 3 of them still have stuff on. She says she doesn't have anything.
Yeah, she was in the dressing room with me, and she doesn't, but I have a bra on.
A bra. Okay. And then the other two have stuff on.
Yeah, they have stuff.
Did you read Miranda to all of them?
Yeah, we got these.
I'm working on ID and everything, so I haven't talked to anyone yet.
Alright.
She just took these off, so I don't, she says that's it.
We had you
They're
just-
talking. Let's do Miranda for everyone.
Yeah, cool. We probably take one at a time and the other one.
Yeah.
No, not right now.
You got a bra on, you said? Yeah, let's go.
Hi. Does an officer talk to you yet? Okay. Hey, officer, don't worry. I got my body camera on. Do you have your ID on you?
No, I don't.
Okay. Have you ever been arrested before? Okay. Here's the deal. We'll typically on these we don't go a criminal route, okay? But we do have like questions and stuff we gotta ask. I know it's a lot right now. We'll work through you with you, okay?
Am I gonna like get arrested?
Not right now. No. You are detained. You are detained. No, it's not. We have to talk to you guys first and figure out exactly what's going on. There's a possibility you could be arrested, but that doesn't mean that's what we're gonna do, okay? Do you have your ID on you?
No.
Okay. What's your first name?
I'm Jada.
How old are you?
I'm 18.
You're 18.
This is what she had on.
Do you go to school here? Okay. What brought you here?
Well, we came here to go. Well, we came here to go shopping, but we didn't really go anywhere because we went to go eat out back.
Okay. Gotcha.
You guys still working on an approximate value?
Yeah, she's getting it now for her, so.
All right. I'll have you hop up and we'll go chat over here, okay? Are you all done with her then?
Yeah, does she have stuff on?
Do you have any of this property?
No, but I have my shirt on, but this is my shirt.
Okay, that's okay.
I wore it.
I'm gonna chat with you in here, okay? Okay. Like I explained, you're just detained right now. We have to read your rights before we're able to talk with you and figure out what happened, okay?
Can you just tell me like the worst that's gonna happen?
Worst, it depends on the amount of property that was
I
taken.
know.
So,
That's what the weird.
yeah. So if it's anything under $300, it's a misdemeanor.
But I don't know how much it was.
We'll figure it
That
out.
Stupid stuffed animal was like, this is like, I don't know why. This is just like,
I promise
I'm
you.
just like,
Hear me out for a sec. I know a lot of people that have committed, these thefts, and it doesn't affect.
It's just.
I know it's a lot, and it
We
doesn't.
both never stolen a candy bar from Dollar General, and now I just think this is a stuffed animal. Like,
I promise you, Jada. Hear me out. It'll be just fine.
About, yes.
Okay. So this is the young lady that just went out.
This is total for everyone?
No, this is total for her.
Okay.
Yeah.
I'll let Dorn know.
So I have to get a lawyer?
No, it's you. You have the right to a lawyer. Do you want me to read them again, or do you understand them?
No, it's okay.
Do you understand the rights? Okay, that's a yes. I just need a yes or a no.
Yes.
Okay, having these rights in mind, can I talk to you? That's a yes. I need a verbal yes or no.
Yes, sorry.
Thank you. Okay, can you tell me the whole story about what happened? Just be honest about it. I promise the honesty goes a lot better.
Okay, so, well, first, our friend told us that I had, like, jelly cats here. So it's like a stuffed animal, and then, like, I came here and, like, other people just, like, told me, like, that stealing's, like, easy. So then, like, I don't know. And I didn't even think about, like, looking at the price tags because I just, like, wasn't really thinking about it. I didn't even know how much those, like, stuffed animals were. Kind of my intention was to, like, come here because I didn't have any money. Is this, like, am I saying this bad?
No, just be honest. Yeah.
Okay, I just don't want to go to jail.
Yeah, no, it's okay. It's
You
okay.
promise it's not going to happen, right?
I can't promise anything, right? Because I don't know all the details yet, but I just have to figure out what happened, okay?
Okay.
So, did you have any money on you?
Well, yeah, I have my card. My
Okay.
credit card, but only like $10.
Okay, so not very much
But I
money.
can pay for the things.
Okay.
All of it. I can
Okay.
pay for all of
We'll,
it.
we'll talk about
right
it later,
now.
okay? Yep. So you came here with the intent to steal then?
Well, no, I was just going to see.
Okay.
I wasn't actually just going to do it.
Okay. And then, do you remember which items you stole?
Jelly cats and then some Skims stuff.
Do you remember the specific ones?
a bra, and then I think underwear. Bra, underwear, and then a pajama thing.
And how did you like take them?
Well, I put the top on, and then the jelly cats I just like put right here. And
Like in your
then,
pocket or something?
Well, like right here. Like
Oh,
right
okay,
here.
like on
Oh,
your
I
pants.
also, I think I actually have the underwear on me.
Okay,
actually.
you can just set that
So
down.
I didn't feel it.
No, you're okay.
Like right here.
Okay.
I put it right there.
When you left, do you know how far you made it? Like, I'm assuming you didn't attempt to pay or anything like that.
No. Well, my cousin was saying like let's go out that way, so we went out that way, and then this guy stopped us, and we just came in with him.
Okay, so did you make it outside the store?
Yeah, but
Okay.
the guy like stopped us, and we didn't get far.
Okay, but you never attempted to pay or anything?
Mm-mm.
That's yes, you never attempted to pay.
Yeah.
Okay.
Is that worse?
No, that's okay. I'm just, like I said, it's not a worse or better thing. It's just I have to understand the details of what happened. Okay? You came here with, these are all your friends, family, anything like that?
One of them's my sister, one of them's my cousin, and the other one's just our friend.
Have you ever been arrested for retail theft?
No, absolutely not.
Okay. With retail thefts, the felony amount is $300. I don't know what your amount is yet. They're pricing it up.
It's like 64. What do you think about that?
Okay, so with that, if you don't have any prior charges and it's $64, I'll write you an ordinance violation. Okay? An ordinance violation is like a speeding ticket, and it doesn't go on your record if it's paid or if you go to court. Okay?
Yeah.
But you got to do one of those two things.
Yeah.
If you neglect the ticket, you then get charged for
Yeah, absolutely.
it, and you'll get a warrant out for your arrest. Okay?
Yeah.
Let me find out the price.
Yeah.
If it's, like you said, just the one item,
Yeah.
and it's that price, and you don't come back,
Yeah.
I'll write you an OV, okay?
Yes.
So I'll have you come back in here.
This one is hers. She still had it on her.
You wearing the rugs that you stole?
No,
I got you taken. That was your car. I just pulled it up.
that was not my car.
That was your car. I can show them right
That's
now.
not my car. I drive a
Whatever white
GMC.
car it is, you were with your friend and you guys both
That's
took Uggs
her
and you
car.
ran out.
That's her car, not my car.
Well, she's getting charged, but I think it was you that was with her.
Mm-mm.
I'll pull it up. It's cool.
Something about Uggs? Did you take any Uggs?
No.
These ones are yours?
Yeah, these are
Did she
mine.
say it was her? Your friend already said it was you and her. Don't lie. I got everything. We already filed a
Okay.
police claim.
Okay, guys, I just don't know what's happening right now, and this is
Well,
just
you're
really
charged
cool.
with that. What's
Just
happening.
be honest about
Ran
it.
out with her
It's
Uggs.
not good to
They
lie
ran around
about
the
it.
building.
Okay, I don't know what. Can someone just please let me know what's happening?
Did you take the Uggs? Yes or no?
Yeah, this was like a long
It was
time ago.
9/9/25. I got it all there. We filed a police report. He just wasn't here when you did it. He was on once, but he had no for it.
Yeah.
Oh,
He's
so this is
the
a
one who
pre.
called me.
This
He
is
said,
a
They're
pre.
wearing our shoes because we had to wait for him to come back. I didn't
okay.
know that was him. So
So this isn't the first time that you've stolen.
Well, from here, because our friend told us that they had like all these things here. We wouldn't have just. We didn't even know about this.
were these from her?
Yeah.
Okay.
We didn't. Sorry, I didn't know they were on me.
That's okay. So, what, do you remember stealing those?
Yeah, it was like a while ago though. I haven't even like worn them or nothing.
Okay. So September, sound right?
I don't know.
Okay. That time when you took the other Uggs, was it just the Uggs or did you take more than one thing?
It was just Sam's.
Okay.
Does this make it worse too? Is everything making it worse?
Well, I can tell you one thing. Lying about it does not help it at all.
Okay.
So just be honest about what happened.
Okay.
Right. That's really all we're looking for, okay?
Okay.
I promise you that most of the time we're able to figure out, like between your criminal history, all that things come into play. Once you lie
No,
about
I'm
it,
not
it's
like
hard.
this criminal or
Yeah,
something.
no, I get it. Okay.
Sorry, I just turned 18 and now like I'm probably getting arrested or tried.
You're just detained right now, okay? We still got to figure out the amount of value and stuff like that, okay?
Okay, but that's high.
What's that?
I don't know how much it is. Can you tell
Yeah,
me?
we're gonna go in and chat right now, okay? If you could just go back in here and we'll sit down with your friends, okay? What's that?
If it's over 300, I'm getting arrested.
We still got to figure out the value. It's a possibility, yes.
Do you have a total for her?
Oh, for her.
Which was
Just this is $34.
34?
Yes, ma'am.
You can just step in and over here, okay? Has an officer spoken to you yet? No. Okay, just got your name. Okay. Okay, so here's the deal. Here, you can have that back. Here's the deal with this. You're technically detained right now, okay? I have to read you your rights before I'm able to talk with you, okay? So let me just do that. And then, okay. Realizing that you want to talk with me. That's a yes. Okay. How old are you? 24. So the biggest thing, I just expect honesty. Like I said, we have to investigate the whole thing fully, but if I come back to it later and, hey, they left out this part, this part, this part, you know, to me, that shows that even though you're caught, you're not really going to change your actions after, right? So can you just explain to me, what exactly did you steal today?
Some Skims stuff, I think, like 3 Skims bras, the Skims pajamas, and then UGG pajamas.
Okay. And then how did you steal those?
I put a bra in my bag, and then
Okay.
I put the other stuff on.
Okay. And did you have intent, like, did you ever go up and try to pay or anything, or you just left?
I just left.
Okay. How far did you make it past the last point of sale?
Well, the dressing room was just right by the door, so I didn't even walk.
So you left out the door to, like, the outside, you made it outside? That's a yes?
Yeah.
Okay. Did you return all of the items? Okay. 100%? You have no, okay. Because Jada still had one on her, so I was like, making sure. What's up, dog?
I would say just we'll pull separate reports for all 4 of them.
Why?
And that's, what are you planning on doing, OV or?
I still gotta look at
Citation.
still gotta look at the values.
Okay, I wrote the one value that the first girl.
Yeah.
I don't know her value.
Okay.
It's going to be the most.
The most value?
Yeah.
Okay. All right. Okay, I think
Is that
that's...
still the same, like what you said before?
Yeah, like I said, it totally depends. Regardless, even if you
Like the
stole...
worst case scenario.
Worst case scenario,
Still get out tonight, no matter
you would
what
still
that
get out
amount is?
tonight. That's correct. Yes.
So 300 is a felony amount for retail theft, which is super low, and
Yeah.
we know that. And it's not
So
hard.
if it's over $300, I have a felony right now?
Well, potentially, yes. Okay. All right. If you can go head back in there, and then we'll chat with you some more and figure out what we're going to do, okay? Okay, so basically what's going on, okay? So we're going to finish up some paperwork. We have paperwork for all of you before we leave, okay? You guys are going to be good to go. You guys have to get processed before you're released, you and her. We're going to be taking you down to a jail, but you'll be released from there. You're not going to be staying, no. You have to go to get processed, okay? It's basically like fingerprints, photographs.
Like, court or something?
There'll be a court date assigned to you, yep.
Like, it's possible to go to jail from this?
Yes, it is possible if you got sentenced to that. Remember that you have no criminal history, right? Okay. So what'll happen is you guys will come with us. I was explaining this, but she explained it.
I just explained it.
Yep. Come get you guys. It takes typically like an hour, 2 hours to get processed in, okay?
What?
We're just talking about the values because you're getting a non-criminal ticket for the first UGG thing.
Think of it like a speeding ticket. You pay it, it goes away.
Yeah.
Are we, like, gonna have to get arrested to go there?
Yeah. You have to be placed into custody. I'm sorry. It's our policy.
Are we in different cars?
Yep.
Okay,
It would be nice.
we gotta do it. So I'll take this. Just put your hands on the wall. Sorry, your sweatshirt's big.
Do you have your paperwork still? It's in your pocket? Okay, cool. I know it sucks being put in handcuffs. Understand it's only temporary, okay? We'll get down there, transport you down there. It's like less than a 10-minute drive. You'll be released from there, okay? It's just a process that we have to go through, okay? And I'll explain everything. If you have any questions, seriously, just talk to me. We'll get through it together.
Both individuals were charged with felony theft, as each possessed over $1,000 in stolen merchandise. They were booked and released with a scheduled court date.
This analysis examines the constitutional protections at play and evaluates whether law enforcement procedures met legal standards. Under the Fourth Amendment, detention requires reasonable suspicion, while arrest demands probable cause. Here, officers possessed probable cause through loss prevention reports and recovered merchandise. The detention was constitutionally sound. Terry v. Ohio established that officers may detain suspects based on specific, articulable facts suggesting criminal activity. Miranda v. Arizona mandates that suspects in custodial interrogation receive warnings about their right to silence and counsel before questioning begins. The Supreme Court defined custodial interrogation as circumstances where a reasonable person would not feel free to leave. This case clearly met that threshold from the moment officers declared detention status. The officer's Miranda administration exceeded minimum requirements. He insisted on explicit verbal responses rather than accepting nods or nonverbal acknowledgments. This creates an unambiguous record demonstrating that the waiver was knowing, intelligent, and voluntary as required by constitutional standards. Berkemer v. McCarty clarified that Miranda applies when objective circumstances indicate the person is not free to leave, regardless of the officer's subjective intent about arrest. The separated interview strategy serves legitimate investigative purposes, identifying inconsistencies, preventing story coordination, and assessing relative culpability among co-defendants. Courts consistently uphold this tactical approach as proper police procedure that doesn't violate any constitutional protections when Miranda has been properly administered. The confession obtained meets admissibility standards. The suspect received proper warnings, provided explicit waiver, faced no threats or coercion, and spoke voluntarily. However, a critical constitutional issue emerges when the suspect clearly invokes her right to counsel. Edwards v. Arizona establishes that once this right is invoked, all interrogation must cease immediately. The standard is unambiguous invocation. Davis v. United States held that statements like, "Maybe I should talk to a lawyer," don't trigger protection, but "I want a lawyer now" clearly does. Under Edwards, police cannot reinitiate interrogation after invocation unless the suspect initiates further communication about the investigation. The officer's response of continuing dialogue about rights and seeking re-waiver creates a potential suppression issue under Edwards' doctrine. While officers may clarify ambiguous invocations, this statement contained no ambiguity. The subsequent questioning arguably violated the bright-line rule established in Edwards. A defense attorney would likely file a motion to suppress all post-invocation statements, arguing the officer improperly induced continued interrogation after clear invocation. The outcome in a suppression hearing would depend on whether the court finds the suspect voluntarily reinitiated contact or whether the officer's conduct was coercive. The officer's interrogation techniques otherwise comply with legal standards. Courts permit rapport building, minimization, and general encouragement to cooperate. Statements that honesty may help are permissible as long as no specific promises about outcomes are made. The officer carefully avoided guaranteeing results beyond his control. Questions about prior uncharged conduct are legally permissible. While these admissions may affect sentencing, they're relevant to establishing pattern, intent, and culpability level. The felony threshold analysis reveals policy tensions. At $300, this jurisdiction's threshold sits below many states that have raised limits to $500 or $1,000. Legislative bodies must balance retail theft deterrence against proportionality concerns. A permanent felony record for an 18-year-old stealing clothing raises questions about criminal justice reform. Courts use retail price for valuation, not wholesale cost. This means premium brands accumulate to felony thresholds rapidly, often faster than young offenders realize. The de-escalation techniques demonstrated represent professional best practices. Acknowledging suspects' fear, explaining procedures step by step, and maintaining calm demeanor reduce resistance risk. The phrase, "we'll get through it together," reframes the officer's role from adversary to guide, which tactical research shows significantly improves cooperation during transport and booking. From a tactical standpoint, the separated interviews, controlled environment, numerical superiority, and body camera documentation all meet professional standards. The transparency about booking procedures fulfills due process requirements. Suspects must understand charges and general process. though detailed legal advice remains the attorney's role, not the officer's. For the lead officer, the grade is A-. Strong legal compliance, tactical soundness, and professional de-escalation demonstrate excellent police work. The grade reduction reflects the Edwards versus Arizona concern. After clear counsel invocation, the officer should have immediately ceased all interrogation. This creates potential suppression risk that could weaken prosecution, despite otherwise strong evidence. Proper handling of this moment would merit a perfect grade. For the primary suspect, the grade is C. Voluntary confession after proper Miranda waiver demonstrates poor legal judgment, despite constitutional protections being available. Admitting to prior uncharged crimes eliminated diversion eligibility and provided sentencing aggravation. However, cooperation, remorse, and returned merchandise prevent a failing grade. The attempted counsel invocation shows some constitutional awareness, though failure to firmly insist after the officer's response proved legally costly. Key lessons emerge from this case. First, Miranda rights exist for protection. Waiving them voluntarily eliminates most defense options and strengthens prosecution substantially. Second, if invoking right to counsel, do so clearly and firmly. Don't waver after the officer's response. Insist on an attorney and cease all communication about the case. Third, retail theft felony thresholds are lower than most young people realize. Premium brands reach felony levels with just a few items. Fourth, for law enforcement, Edwards provides a bright-line rule. Once counsel is invoked unambiguously, all interrogation must stop immediately to protect both rights and evidence admissibility. Fifth, first-time offender diversion programs offer rehabilitation opportunities, but eligibility often requires true first offense with no prior uncharged conduct pattern. Finally, what seems like casual shoplifting with friends can result in permanent felony records affecting employment, education, housing, and opportunity for years. This case demonstrates both excellent police procedure and critical constitutional issues that courts will weigh when evaluating evidence admissibility and rights protection. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to the channel for even more police interaction and courtroom content.